Hi, I'm Richard Karn, and you may have seen me on TV talking about the world's #1 expandable garden hose. Well, the brand new Pocket Hose Copperhead with Pocket Pivot is here, and it's a total game changer. Old-fashioned hoses get kinks and creases at the spigot, but the Copperhead's Pocket Pivot swivels 360 degrees for full water flow and freedom to water with ease all around your home. When you're all done, this rust-proof anti-burst hose shrinks back down to pocket size for effortless handling and tidy storage. Plus, your super light and ultra durable Pocket Hose Copperhead is backed with a 10-year warranty. What could be better than that? I'll tell you what, an exciting radio exclusive offer just for you. For a limited time, you can get a free Pocket Pivot and their 10-pattern sprayer with the purchase of any size Copperhead hose. Just text WATER to 64,000. That's WATER to 64,000 for your 2 free gifts with purchase. WATER to 64,000.
By texting 64,000, you agree to receive recurring automated marketing messages from Pocket Hose. Message and data rates may apply. No purchase required. Terms apply. Available at pockethose.com/terms.
Hi, I'm Richard Karn, and you may have seen me on TV talking about the world's #1 expandable garden hose. Well, the brand new Pocket Hose Copperhead with Pocket Pivot is here, and it's a total game changer. Old-fashioned hoses get kinks and creases at the spigot, but the Copperhead's Pocket Pivot swivels 360 degrees for full water flow and freedom to water with ease all around your home. When you're all done, this rust-proof anti-burst hose shrinks back down to pocket size for effortless handling and tidy storage. Plus, your super light and ultra durable Pocket Hose Copperhead is backed with a 10-year warranty. What could be better than that? I'll tell you what, an exciting radio exclusive offer just for you. For a limited time, you can get a free Pocket Pivot and their 10-pattern sprayer with the purchase of any size Copperhead hose. Just text WATER to 64,000. That's WATER to 64,000 for your 2 free gifts with purchase. WATER to 64,000.
By texting 64,000, you agree to receive recurring automated marketing messages from Pocket Hose. Message and data rates may apply. No purchase required. Terms apply. Available at pockethose.com/terms.
This is a perfect time for us to talk about what this will be, and that is Hot Shadow Docket Summer. I'm Kimberly Atkins Stohr, and welcome to Justice by Design, where we talk about solutions and how to make our society a better one. And one of the biggest things that we need in order to have a just and fair functioning society is a judicial system that works. And today we're going to be discussing just how well the Supreme Court is working. And aside from my wonderful sisters-in-law co-host, I can't think of anybody else that would be better to talk to this with than Leah Littman, who is a professor at the University of Michigan School of Law, as well as author of the new book, Lawless: How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. Which is out, and it's wonderful. I highly recommend everybody read it. Come for the movie references alone, but there's a lot more really, really good stuff. Leah, thank you so much for joining me today.
Thank you so much for having me. I took the comparison to your co-host, the sisters-in-law, as the highest compliment it was intended as.
Well, we often get asked a lot, like, when are you guys doing a crossover? And it's like, I see you all in various places, but
we need to make it happen. I know there are many hosts on both shows. And so a 7-person co-hosted episode might be a little unwieldy and yet still wonderful, I'd imagine.
Yes. And, it's not like any of us are that talkative at all either, right? So yeah, that would work seamlessly. But thank you for joining me today. With all my guests, I always ask them to give themselves a quick 30-second introduction to our listeners, any who may not know who you are. I can't believe that there are many, but tell us a little bit about yourself and what you do there at the University of Michigan.
I am a Midwesterner at heart who came back to the University of Michigan Law School, where I graduated from to teach, and I focus on constitutional law and the federal courts. I think my interest in those areas really stems from my time clerking at the court, which I'm happy to talk more about later. But I also co-host Strict Scrutiny podcast. I write and skeet and offer public commentary on the court as well. And I live in Ann Arbor with my partner and my dog, Stevie Nicks, where we listen to a lot of Taylor Swift.
And you have to follow Leah on socials just for Stevie alone. Stevie is awesome. I would love for Snickers and Stevie to have their own little powwow, right? I'm sure they would have a lot to say.
Oh, yeah. Stevie loves other dogs. She would be beyond thrilled.
Yeah, then we'll have to make that happen. We'll have to consult with their agents,
I'm
and
the
make that
momager here.
happen. So this is a very newsy week when it comes to the U.S. Supreme Court. I do want to talk about your book, but I think right now the decision in Scrimetti is on a lot of people's minds, the folks who are following the court closely. It was not surprising, but it was still shocking, I think it's fair to say. Of course, this was the decision in which the Supreme Court upheld a Tennessee law which barred gender-affirming care for trans minors. What were your thoughts about this opinion, the vote count, and anything else that comes, that struck you the most about this ruling?
Yeah, so I agree with you. It wasn't surprising, but I think what struck me on reading it is just how deeply disingenuous and convoluted the logic was. And in a lot of ways, it confirms a major theme I write about in the book, which is the Republican justices' insistence that there is no discrimination against the LGBT community, and to insist that such discrimination isn't actually discrimination at all. Because in Scrimetti, the 6 Republican justices said, this law, which, by the way, references sex 19 times and prohibits medical treatment that is not in conformance with sex, is somehow not a classification based on sex and isn't sex discrimination. Big if true. And then second, perhaps more outlandishly, the justices said this law, which bans gender-affirming care, so the provision of hormones and puberty blockers to treat gender dysphoria, the condition where your sex assigned at birth does not align with your gender identity. They said that didn't discriminate against trans people or on the basis of gender identity, which, again, big if true, I don't know any cis people who are seeking treatment for gender dysphoria, but that didn't seem to bother them.
Yeah, that was really what I wasn't quite sure. I knew it was going to take some gymnastics to get to the outcome that I expected, which is what the outcome that they reached. But I expected legal gymnastics more than logical gymnastics. Yeah, because to say that, this statute, I mean, this is essentially what Chief Justice John Roberts wrote, is that this statute doesn't categorize based on sex. It categorizes based on age, since it applies to minors, and medical procedure. No. It's like so essentially, in lay person's terms, that this doesn't even create much of an equal protection problem because it's not a gender-based distinction. Now, what was argued, I thought very well in court, was that, well, of course, it's a gender distinction, because if you are, say, a teen woman who needs hormone treatment to deal with a reproductive health issue, or you need a puberty blocker because you started puberty at 8 or something like that, you can get all of that in Tennessee. The only reason you wouldn't be able to get it is if you're trans, which is a distinction based on sex. And I mean, you can't spell transgender without gender. So I just thought that was a choice, right? That was a choice by the Chief Justice to go that way. But it could have been worse, because 3 of the 6 in the majority would have gone farther. Can you talk a little bit about that?
Yes. So the 3 that would have gone farther, and I think it's important to identify who they are, were Justices Thomas, Alito, and Barrett. And all 3 of them said, even if this law did discriminate against trans people, that is, even if we concluded it did indeed discriminate on the basis of gender identity, we still would treat it as presumptively constitutional and kind of give the legislature a pass. And that is really concerning, because it seems to invite more targeted and invidious discrimination that is specifically and overtly directed against the trans community, which has already been facing so much anti-trans hysteria and policy.
Yeah, it really, really has. So I want to zoom out a little bit and sort of look at this decision, which is one of, if not the biggest decision on the court's docket this term, the biggest case, and sort of what do you draw from this ruling about where this court is at this moment?
I would say two things. One is, I think this decision is very consistent with a stark pattern in which the justices deny that any historically subordinated group or any group that is truly politically powerless, they deny that those groups are the victims of discrimination. Like the only group that they are convinced faces discrimination today are groups that are affiliated with the core Republican base, be it white religious conservatives, white social conservatives, white Christian men, the mega rich, the corporate executive. They think that those people are the victims of a discrimination. And so it's that thread that I think this decision is totally consistent with. The second is, I would say, this decision, like Dobbs and others as well, really reveals the broader ideological project that is motivating the Republican justices, which is this weird nostalgia for the past and an incredible interest in reviving cases from before the feminist movement, before the civil rights revolution, and taking law and society back to that time.
Yeah, so this is a great segue into your book because you talk very much about that. I appreciated how you sort of started with the patriarchy of the court and seeing and basically making the argument that the folks who are benefited most by the decisions of the current court tend to be those who I should say, I was going to say, white men, but not even just white men, those who believe that they benefit from the empowerment of white men, and that
Yes.
that group is
Yep.
broader than white men alone. Why did you start at that point in the book?
So I started there because I think Dobbs, when the moment the court overruled Roe, was a real flashpoint as far as public concern about the Supreme Court went. And so I wanted to begin with an example that felt familiar. I also think it is one of the areas of law where the relationship between law and doctrine and how the justices interpret the Constitution and politics and social movements is so clear. And so I was able to offer an illustration of here's this thing, originalism, which you might think is this neutral principle of interpreting the Constitution, but actually its origins were in reactions and backlash to Brown versus Board of Education and the feminist movement.
Hi, I'm Richard Karn, and you may have seen me on TV talking about the world's #1 expandable garden hose. Well, the brand new Pocket Hose Copperhead with Pocket Pivot is here, and it's a total game changer. Old-fashioned hoses get kinks and creases at the spigot, but the Copperhead's Pocket Pivot swivels 360 degrees for full water flow and freedom to water with ease all around your home. When you're all done, this rust-proof anti-burst hose shrinks back down to pocket size for effortless handling and tidy storage. Plus, your super light and ultra durable Pocket Hose Copperhead is backed with a 10-year warranty. What could be better than that? I'll tell you what, an exciting radio exclusive offer just for you. For a limited time, you can get a free Pocket Pivot and their 10-pattern sprayer with the purchase of any size Copperhead hose. Just text WATER to 64,000. That's WATER to 64,000 for your 2 free gifts with purchase. WATER to 64,000.
By texting 64,000, you agree to receive recurring automated marketing messages from Pocket Hose. Message and data rates may apply. No purchase required. Terms apply. Available at pockethose.com/terms.
Hi, I'm Richard Karn, and you may have seen me on TV talking about the world's #1 expandable garden hose. Well, the brand new Pocket Hose Copperhead with Pocket Pivot is here, and it's a total game changer. Old-fashioned hoses get kinks and creases at the spigot, but the Copperhead's Pocket Pivot swivels 360 degrees for full water flow and freedom to water with ease all around your home. When you're all done, this rust-proof anti-burst hose shrinks back down to pocket size for effortless handling and tidy storage. Plus, your super light and ultra durable Pocket Hose Copperhead is backed with a 10-year warranty. What could be better than that? I'll tell you what, an exciting radio exclusive offer just for you. For a limited time, you can get a free Pocket Pivot and their 10-pattern sprayer with the purchase of any size Copperhead hose. Just text WATER to 64,000. That's WATER to 64,000 for your 2 free gifts with purchase. WATER to 64,000.
By texting 64000, you agree to receive recurring automated marketing messages from Pocket Host. Message and data rates may apply. No purchase required. Terms apply. Available at pockethost.com/terms.
Yeah, and talk about how those things go hand in hand, because sometimes folks are surprised when I say, well, what birthed the modern anti-abortion movement as a political movement really was the fight against desegregation. That was the through line that went through.
You should be so
in this.
proud.
So talk a little bit about that.
Yeah, so I think there's two parallels that are worth highlighting there. One is that the very methodology of originalism was really first trotted out as a way of attacking Brown versus Board of Education. The segregationists insisted that a decision invalidating segregation in public schools was inconsistent with the original intent of the 14th Amendment, given that the amendment was passed by a group that sent their children to and operated segregated public schools. So it has its origins in support for segregation and opposition to integration. And then it really gets revived and takes off during the Reagan administration as a cudgel against what Reagan's attorney general described as the excessive civil libertarianism and egalitarianism of the Warren Court, namely that court's recognition of civil rights and civil liberties for groups that haven't always been part of the American political society and political life, who haven't been allowed to participate fully. So it's that parallel. And then second is just, as a methodology, originalism lends itself to taking away rights from groups that weren't fully included in American politics, because Justice Alito's version of originalism said, let's determine what rights we have today by looking at what rights were protected in law in the 1700s and 1800s. Well, guess what? At that time, as everyone knows, women, people of color, were not allowed to vote. So the laws did not recognize them as full and equal citizens with rights. So as a methodology, and again, its origins, originalism is a project of rolling back the civil rights movements.
And that's a really interesting way of looking at it, even in terms of the Scrimetti decision, because originalism is, just as you pointed out, this idea that the text says what it means, what it says, and it means what it said when it was written. And both when it comes to interpreting the Constitution, but also statutes, like in the case yesterday, the statute, as you pointed out, 19 times it uses the word sex. I tried to post a Teresa Giudice gif with that, of the 19
flipping the
times.
table. Yes,
about it. But still, somehow, the Chief Justice is like, no, that's not what it says. So to me, I feel like the battle, the what you do so well, explain exactly how originalism is sort of disingenuous in the way that it's written, knowing our history, that the people, women, people, even people who didn't own land, all kinds of people were not a part of this experiment of freedom and democracy and of equal rights. So that is already tainted, although I do appreciate Justice Jackson's 14th Amendment originalism, which talks extremely clearly about what was going on at that time in the efforts to reconstruct this nation after the Civil War. But yesterday, it wasn't even about that. It's sort of like they've given up the pretense and are just pretending that laws don't say what they actually say. Is that a new shift in this court, or is this an extension of what they've done before?
I think it's an extension of what they've done before. I really think this project is a by any means necessary, and sometimes originalism isn't going to get them where they want to go. And so they just resort to other means. So take Shelby County versus Holder, the decision invalidating a key provision of the Voting Rights Act. on this cockamamie theory that Congress can't differentiate between the states based on their histories of voter discrimination, that would be a big surprise to the Reconstruction Congress, which put the former Confederacy under military occupation. So the justices didn't even bother to consult with originalism. They just made up this principle. And I honestly think this has been a pretty common theme in the cases on LGBT equality, where the court just pronounces by fiat that, of course, the Constitution protects the prejudices of the conservatives who are opposed to LGBT equality, because that's just the way it is, and it isn't even discrimination at all. So I'm happy to give examples of cases that I think are like that, but I actually think Scrimetti is part of that pattern.
Yeah, and you do. I appreciate that you give a lot of space for LGBTQ rights in the way that the court has handled them in your book. And I sort of thought, a decade ago, I thought, okay, the court is on this trajectory from Bowers v. Hardwick, which upheld a criminal sodomy statute, to Obergefell in 2015, that was 2015. Yes. I remember being in the courtroom when Justice Kennedy was reading.
Same, I was there too.
Yes. And it was just like, wow, you could see this trajectory of the court. So how did we get from Obergefell to Scrimetti?
I mean, I think what the trajectory reveals is victories are never permanent. On the upside, that means losses aren't either. The law is always changing. People are always pushing back and fighting to move the law in a particular direction. So progressives cannot rest on their laurels and just assume that the victories that have been obtained are going to be there forever. It's a constant project of reinforcing our democracy and civil rights, bolstering the wins we have, continuing to sustain them, and fighting for additional rights and liberties as well. And I just worry that too many on the left began to view the court as an institution that was inherently likely to protect the rights of sexual minorities, the LGBT community, and that was just a woefully incomplete narrative that failed to recognize the contingencies of how the law developed as it did.
So I want to ask your views on a couple of the justices. Somebody who I am asked about, like by my friends and family members and, people on the street, who has been getting a lot of attention lately, is Justice Amy Coney Barrett. Recently, even conservative political figures have assailed her as a woke hire, a DEI hire, because her decisions did not seem to fall in line at all times with the conservative /MAGA/Trump agenda. Certainly, that did not seem to be the case with her vote in the Scrimetti decision. She wasn't just in the majority, but she was in the plurality of conservatives who said, yeah, we'd go further and just state outright that equal protection does not apply, even if this was a sex-based distinction for transgender people. My husband calls her the most interesting justice on the court. What is your assessment?
I mean, three things, if I can. One is that, of course, the MAGA heads are going to scream their faces off anytime they don't get exactly what they want from all of the Republican appointees. The story of it never being enough is the story of the Republican Party vis-a-vis the Supreme Court. We've been hearing for decades about how the court is controlled by liberals and woke and progressive. Newsflash, there has not been a majority of Democratic appointees on the court for more than 5 decades. Yeah. So for Republicans, it's never enough. And I think we should understand the complaints against Justice Barrett and others for that matter as just being part of that trend. And what they do is they amplify and I think over exaggerate the extent to which any particular Republican justice is deviating from the core Republican project and deviating from the other Republican appointees. And second is all of the Republican appointees have their kind of quirky issues. For Justice Gorsuch, it's federal Indian law. For Justice Barrett, it happens to be this small segment of cases on executive power and federal power. So And those cases are taking on additional salience right now. But the fact that they are especially relevant should not distract us from the fact that, again, she is in lockstep with, if not to the right of, some of her colleagues on these big social policy issues or voting rights or you name it. So that's kind of the second thing. And then the third is just get real. Like, I get the desire to make the justices and the court more interesting than a bunch of people who usually vote their partisan ideological priors. As a lawyer, I love focusing on the law and the technical and the procedure. And it seems like that's only relevant in a small number of cases. But I don't think our focus on those should obscure the bigger picture and story about what the Republican justices are doing.
That's a very interesting answer. I have been thinking, I sort of have resisted this idea that Amy Coney Barrett is this, wild card who could, all of a sudden when you least expect it, be the vote that helps hold our democracy together. If you just look a few episodes ago, I had Adam Feldman on and we were, nerding out over SCOTUS data. It's like by any metric, she is a solidly, reliably conservative vote on this court. On different issues. I mean, it doesn't say that she's not thoughtful, and her jurisprudence differs from her colleagues in certain ways, and that's what you're seeing. You're seeing her stay true to her own views, whether it's procedural issues or the thorny technical things. But by and large, her broader view is right in line with the conservative majority, and I think Scrimetti was a key example of that. And one thing that did sort of shock me in Scrimetti was the silence of Neil Gorsuch. So recall that Neil Gorsuch authored the opinion, which held that Title VII, the federal workplace anti-discrimination statute, which prohibits discrimination on the basis of sex, applies also to discrimination on the basis of sexual orientation or gender identity. And that case was relied heavily, even though that was a statutory interpretation case, that was relied on heavily in Scrimetti to say, hey, you can do that same analysis for equal protection constitutional claims like this one. If saying discrimination on sex means LGBTQ folks in a statute, how come it doesn't mean that when it comes to interpreting the Constitution? Not only was Neil Gorsuch in the majority saying that it didn't, he did not issue a concurrence. He didn't give a smoke signal. He didn't say a peep. He didn't say a thing. What did you take on that?
I mean, it's a reflection of how entitled and monarchical I think some of the justices view themselves. Like, he didn't feel like he had to offer an explanation. I think partially in his mind, his opinion in Bostock is this paean and pinnacle of textualism that just shows he is this neutral expert when it comes to interpreting statutes. And to his mind, that just isn't relevant to the issue in Scrimetti, even though I understand they're different, but surely they're related.
Right.
But I think because that's how he views Bostock in his mind, he might not have understood how people thought. Like, you got to say something, dude.
Yeah, this is some sort of distinguishing. I joked to my husband, who most listeners know is a reporter for Bloomberg News covering the Supreme Court for a long time. And I joked, and I said, hear me out. Maybe if the next challenge involving trans rights is about the tribal rights of a minor trans indigenous child who needs to be protected. Maybe if it's presented in that posture, Neil Gorsuch will go, oh, because he is probably, as you pointed out, like, he is the most staunch defender of indigenous rights on the court right now, which is very interesting. He was on the federal court that was based in Colorado for a long time and ties out there. So he's seen a lot of these cases and adjudicated over them. But maybe that might have helped him get on board somehow. I don't know. That's just conjecture on my part. It wouldn't be right, given given that he's the author of the Scrimetti decision, to not ask your take on the Chief Justice. John Roberts, he has gone, to me, this is just my opinion, and you give me your thoughts, from sort of being cast aside as a leader in the court once the majority tipped over to a 6-person majority, and it became clear that the conservatives didn't always need him to have their way, and that was a loss of power. It seems that he's reasserting his power in a very measured way this term. And I think the Scrimetti decision is an example of that. What do you think?
I totally agree. He wanted to control how the Supreme Court reached the result that it did in Scrimetti, because if you give that opinion to someone like Thomas, Alito, or Barrett, you know it's going to go further. You know it's going to have a ton of anti-trans screeds, you know, more so than the majority. And so I do think he wants to control the pace at which the Supreme Court is deciding these issues. But I also think we should pause to note that before Amy Coney Barrett was the most interesting person on the Supreme Court, it was John Roberts, who people said saved the Affordable Care Act, or voted with the Democratic appointees on DACA rescission, or the citizenship question on the census. And again, I just think you're always going to be able to identify some cases, again, except for Thomas and Alito, where a Republican appointee sometimes joins with Democratic appointees, and that just does not and cannot and has not meant they are moderate, drifting left, and we should view them as a gettable vote in many of these big ticket, ideologically salient, high profile cases. I mean, this is the guy who wrote the immunity decision.
Yeah, that's absolutely true. Just by the by, I'm noticing as we're talking that you refer to the justices as the Republican justices and the Democratic justices. Why is that?
Yeah, so I just think we can call them Democratic appointees and Republican appointees, but I just worry that that phrasing obscures the extent to which they are Republican politicians. They're not the same kind of Republican politicians that we elect to the White House or we elect to Congress. But my goodness, you know, 5 of the Republican appointees served in Republican politics, and the other, Amy Barrett, was on the Bush campaign legal team. So I think it's totally fair to call them Republicans. That's what they are, and that's how they behave on the Supreme Court.
Hi, I'm Richard Karn, and you may have seen me on TV talking about the world's #1 expandable garden hose. Well, the brand new Pocket Hose Copperhead with Pocket Pivot is here, and it's a total game changer. Old-fashioned hoses get kinks and creases at the spigot, but the Copperhead's Pocket Pivot swivels 360 degrees for full water flow and freedom to water with ease all around your home. When you're all done, this rust-proof anti-burst hose shrinks back down to pocket size for effortless handling and tidy storage. Plus, your super light and ultra-durable Pocket Hose Copperhead is backed with a 10-year warranty. What could be better than that? I'll tell you what, an exciting radio-exclusive offer just for you. For a limited time, you can get a free Pocket Pivot and their 10-pattern sprayer with the purchase of any size Copperhead hose. Just text WATER to 64,000. That's WATER to 64,000 for your 2 free gifts with purchase. WATER to 64,000.
By texting 64,000, you agree to receive recurring automated marketing messages from Pocket Hose. Message and data rates may apply. No purchase required. Terms apply. Available at pockethose.com/terms.
Yeah. So I was thinking about what I am still waiting for in these final days of the Supreme Court term. And the biggest case I am waiting for now that Scrimetti has been decided isn't even on the court's merits docket, which I think this is a perfect time for us to talk about what this will be, and that is hot shadow docket summer. There is a lot on the court's so-called shadow docket. You can call it the emergency docket, but these are cases that aren't meant to be fully briefed like a case like Scrimetti. They often don't get arguments, although in this case it did. And I'm thinking of the nationwide injunction case as part of the challenge to the birthright citizenship order. But talk about that, and also just talk about the shadow docket, which is where most of the action has been these days. There are constant petitions being made for the court. Just this week, we saw one on Donald Trump's tariffs.
Yep.
That are coming up, and there is no end in sight to them. They're going to keep coming through all summer. It's going to make it really hard for the justices to, traipse off to some faraway place to get away, or at least they'll have to stay close to their phone. So this is really the year of the shadow docket. What do you think might happen in the nationwide injunction case, which seeks to stop a single judge from being able to halt a policy like one of Donald Trump's executive orders, and the other shadow docket cases that we're seeing come with just in a ceaseless pace?
Yeah, so I'll start with the nationwide injunction case. I guess my read on the oral argument is the Republican justices really want to narrow and limit the availability of nationwide injunctions, and I think they are going to say some things in this case to do so, whether that is requiring courts to use particular procedures before awarding that kind of relief, or requiring plaintiffs to jump through particular hoops or obstacles to do so. I don't think they are going to absolutely prohibit them, however. And so that's kind of what I'm expecting them to do. And the concern or issue for me is whether the things they say too severely restrict the availability of nationwide injunctions. I think particularly in a case about immigration, nationwide relief is oftentimes the only way of maintaining a uniform rule of naturalization, which the Constitution requires. Uniform rules of citizenship under the 14th Amendment also required. So I'm watching to see what limits they adopt and what, if anything, they say about whether nationwide relief is appropriate here. In the best case scenario, they'd also say birthright citizenship is a thing, guy. This order is obviously unlawful. I don't think they're going to say that, but girl can hope.
They so could have. I wrote a column saying, look, there's an easy way to deal with this. You don't even have to touch nationwide injunctions.
No.
Which, to be fair, the issue of nationwide injunctions is a real one. Right.
Yes.
Where this isn't just, and it isn't a one side. I mean, one of the most damaging nationwide injunctions, thankfully, in the end, it ended up being not being as catastrophic as it could be. But it was with one federal judge in Amarillo, Texas, deciding that he is the FDA and wanting to take mifepristone off the market. Like, that's a nationwide injunction, too. They can go too far. There are places where you need them, like when you're trying to strip large portions of people of the ability to have their children be citizens when they are born in this country. But there are other places where it makes no sense at all for them to be. And that, honestly, is a congressional issue. But we don't have a functioning Congress right now. But so now it's up to the Supreme Court to try to draw these lines. It's not even the right way for it to be done. But here we are. But it's attached to a case where the constitutional issue seems so clear. Even it cannot be a majority of people who think that a president with an executive order can strip birthright citizenship from people. So they could have avoided that.
Yes. And the fact that they took it up in this case, which is such a poor vehicle, when they had so many other opportunities to do so in better vehicles, just reeks of hypocrisy and is part of my concern.
How weird is it that the court is going to be so busy this summer? Usually summer is a time that we can have a couple of months of a break from thinking about the court. I envisioned when I started my Supreme Court newsletter that I'd have the summers off, and I was disabused of that notion by my editors, who said, "Oh, no, you have to keep the end of the term is not the end of your newsletter." No. How weird is this? I mean, it seems really strange, but it also seemed inevitable given what the president is doing.
Yeah, I mean, I think this is a stark departure from where we were 10 years ago, but I think that this is something that changed during the first Trump administration. As soon as that administration started rushing off to the Supreme Court anytime they got a lower court decision they didn't like, and the Supreme Court didn't tell them to knock it off, they encouraged it by occasionally and even often granting their requests for emergency relief. And so as long as the court is going to do that and continues to do that, we are going to continue with this frantic, erratic, unplannable, chaotic season where you never know when you're going to get a potentially hugely significant consequential Supreme Court action, and it might never be explained. So this is a change, but it's a change that I really saw during the first Trump administration, although I do think it's gotten worse since then.
So I like to leave with the what can people do question, because that's always what I'm asked after a podcast episode like this. With the Supreme Court, it's different than other issues I've talked about on this podcast, in that they are appointed for life. The judiciary was meant by our founders, speaking of originalism, to be separated from the political winds that blow, but that hasn't worked out in that way. That's actually worked to insulate them from accountability, in my opinion.
Yes.
So what can people do? People who see the Supreme Court and say, I don't want 6 Republican politicians and 3 Democratic politicians. I want a body that really is there to ensure the words on the building, equal justice under law. So what can people do?
Yes. So I think the reality is people need to recognize that changing an institution like the Supreme Court takes time. It took almost 5 decades for the Republican Party to construct this 6-3, right-wing supermajority that allows them to do almost everything they want. But I do think there are a few steps that people should invest in to make that change happen over the long term. One is public information and public education. We need to build a coalition that understands the importance of the Supreme Court and how every single election at the state, local, and federal level matters for the future of the courts, and understand what's at stake when we go to vote. Are you going to vote for someone who wants to appoint justices who will allow the mega rich to infuse unlimited amounts of money in our elections, or are you going to vote for someone who actually believes in political equality? That's kind of the choice. Second is organization. If everyone who participated in the wonderful No Kings protests on June 14th got involved in local government and organizing, gosh, that change would be immense. And so I understand everyone is busy, but trying to find ways to engage in voter education, voter turnout, and organizing between elections, so you're not just approaching people during election season,
Yes.
and building the infrastructure and the network before then, I think that's super important. And then third, find a way to use whatever your special talent is to participate in this fight and make it sustainable. Everyone is good at different things. Some people are really great at protesting. Some people are really great public commentators. Some people are great artists. Some people are great writers. Some people are going to be great politicians. Figure out what you can do and you can add in a way that will allow you to continue to do that work for the next several decades.
Yeah, I love that you say that, because I think people, when they say they don't know what to do, they actually do. They just haven't thought about it in terms of what their strengths are. And I think that's such a perfect way to do it. It doesn't have to be marching in the street and holding a sign. It can look like any number of ways. But I really echo what you said about take that energy that we saw this past weekend and don't just let it dissipate. Channel it into something else. It can be small. It can be community based. A lot of the best pro-justice efforts that are going on right now are happening at the community level. I've highlighted some of those folks on this pod, but it really is happening in that way, and it's really incredible. And it will take time, as you said, but it can reach even the highest court in the land. Leah Littman, I appreciate you using your talents not only to educate the kids in Ann Arbor, but also have the great podcast of Strict Scrutiny. I'm actually doing a panel with your co-host in Aspen next week.
Oh, Melissa, wonderful.
I will be happy to see Melissa, who is also a dear friend of mine, and maybe one day we'll get the seven of us all.
We'll have to
together
block out 7 hours, but
hashtag Sisters in Scrutiny.
Yeah.
We will get it done. Leah Littman, thank you so much for joining me today.
Thank you for having me.
And thanks to all the listeners for joining us. Don't forget to subscribe to Justice by Design wherever you get your podcasts. You can also check it out on YouTube. Be sure to give a great rating wherever you're listening or watching this episode, because that helps other people find it. And I will see you next week with another episode of Justice by Design. I'm Kimberly Atkins Stohr.